Good morning and welcome to our webinar this morning on Lloyd versus Google. My name is Martin Stone. I'm one of the partners in the commercial services team at Brodies and one of the data protection specialists. I'll be speaking today alongside my colleagues Craig Watt and Niall McLean, who are in our litigation team. And I suppose we'll just jump to the agenda. So for those of you that have attended our biannual data protection update, you'll be probably well aware of the importance of this case at Lloyd versus Google and the Court of Appeal's previous decision, which potentially exposed Google to damages in excess of £3 billion. You'll probably have seen quite a lot of commentary from lots of people on this case over the last couple of weeks. But what we want to do today is do something a little bit different, and that is to look particularly at the impact of the decision Lloyd versus Google in relation to privacy claims and group actions in the Scottish courts. So looking at this case, which is a Supreme Court decision in English courts, and trying to see what that means for claims in Scotland. So hopefully something a little bit different to some of the commentary that you may have read so far. The format for this morning, I'll kick off just with a bit of background to the case and the court's decision. I'm then going to hand over to Neil, who's going to talk about the data protection and misuse of private information issues here. And then Craig will talk about some of the procedural issues in terms of English court procedure and what that means for Scotland in particular around class actions. Okay, so we're now on to just going to the background, so move to the next slide. So what's this all about? Well, this all comes from a case a few years ago, actually also involving Google as well, Vidal Hall, which you may have heard us speak about before, which confirmed that individuals can claim damages for pure distress for breaches under the Data Protection Act 1998. And the consequence of Vidal Hall was that led to lots of attempts to bring class actions following high-profile data breaches, and you'll no doubt have seen some of the newspaper advertising that has followed, big breaches involving the likes of British Airways. But there's been quite a few challenges around that in terms of how those claims are brought. So number one, bringing a claim against someone like Google for a breach is going to be expensive. It's going to be a long process, but those individual claims are all very small in value. And when you're looking at damage and distress, that's going to vary from person to person. What I may suffer as a result of a breach will be different to what someone else suffers. So that makes things more complicated. And while there is litigation funding available for these claims, we'll talk a bit about that as we go through this morning's session, you need large numbers of claims in order for it actually to be viable to use the litigation funding model. So individual actions can be brought, but they're potentially quite expensive. You can use under English court procedure group actions, but you need people to actively opt into that group. So you've got to get people to actually want to take part of it. And so what Lloyd and Google is about is a third way called representative actions. And that can be used where you have claimants who have the same interest. So that's a potential way forward here. So Lloyd versus Google, the background to this, it goes back actually to 2012 and alleged breaches of data protection law by Google. So this was all to do with trying to introduce workarounds to deal with some of the privacy protections that Apple had introduced to the Safari browser on iPhones and iPads, which limited the ability of website operators to track users in terms of what they're doing and across devices. And what Lloyd was trying to do was bring a claim for damages for simple loss of control of data, or loss of control of personal data. So not for the actual sort of damage or stress that was suffered in terms of financial loss, but simply saying, you've lost control of my data and therefore I'm entitled to damages for that. Now, why was the claim brought in that way? Well, it was a representative action. So going back to my point before about how this is done, and he was working with litigation funders, there was a representative action on behalf of the estimated 4 million users who were affected by the alleged breach at the heart of this case. And the point here in terms of why it was structured in this way is that for representative action, you have to have everyone who has the same interest. And by structuring this as a claim for loss of control, everyone in that class had been affected in the same way because everyone had been in a position of having their data, lost control of that data, and therefore you can claim uniform damages for that, so everyone would be entitled to the same amount, and it was I think about £750 per user for that. So that was the structure of the claim and why it was being brought as this representative action. In order, because Google is incorporated outside the UK, they had to get permission from the court in order to serve proceedings outside the UK. And so that required the court to have a look at whether there was a reasonable prospect of success in this case. And that's what the courts have been working through over the last couple of years. The initial application was rejected by the High Court, but then overturned on appeal. And so the consequence of that decision from the Court of Appeal was potentially to open floodgates to huge damages claims. So in this case, I think you mentioned, £3 billion worth of damages potentially just for this case alone. But the consequence here, if the court was to uphold the principle of damages for loss of control of data without needing to show any actual loss being suffered by the individual, would mean that for cyber attacks and other data breaches, that you potentially have huge exposure for businesses and other organizations and indeed their insurers. So a hugely important case, and that's why we've all been very interested to wait and see what the Supreme Court is going to say. So what did the Supreme Court say? Well, they upheld Google's appeal. So on the 2 points at the heart of the case, on the point around damage for loss of control of personal data, the Supreme Court said, well, that is recoverable for an action for misuse of private information, but it's not possible for claims under the Data Protection Act 1998. So in order for you to bring a claim for damage under the Data Protection Act, you need to be able to show your actual damage and distress, and that's going to be fact specific to each individual. So the damage that I suffer may not be the same as you. You can't just claim a uniform amount for every individual. And therefore, when looking at representative actions and remembering that we need to have this common interest, that means you can't use a representative action approach for those claims for damages. The court said you could use it for establishing liability. So the fact whether has there been a breach or not, you could use representative actions for that. But when looking at the actual damages that would then be due if a breach is established, that would require a personal assessment. And that's going to have, I think, quite a big impact on claims arising out of cyber incidents and other personal data breaches, because while a representative action can be used to establish liability, from a funder's perspective, that's much less attractive because you're not then actually dealing with the claims that follow when damages are actually paid out under it. And the other thing that we've had in recent weeks is another case, which you may have picked up on, called Warren versus Dsg Retail. So this is the Dixon's Curry's group, where an individual brought a claim as well, and this was following a cyber attack. And at the same time, the Google Lloyd decision, we've also had Warren say that claims based on misuse of private information are also not available to be used where you're dealing with a cyber attack. So two very interesting cases, which I think have very much narrowed the ability of individuals to make claims arising out of cyber attacks or other breaches of data protection law. So that's just a quick overview of the background. I'm now going to hand over to Neil, who's going to dive into a bit more detail on the data protection issues and also talk a bit more about misuse of private information.
Thanks very much, Martin, for that introduction and helpfully setting the context of the decision. So I'm going to look at the data protection issues in a bit more detail, and starting with data protection. So what was the issue in this case? Well, what the claimant wanted to do was to try and break new legal ground by suggesting that the approach to damages in misuse of private information cases, primarily about phone hacking, also applied to the assessment of compensation under Section 13(1) of the Data Protection Act 1998. And it's important to remember here we're dealing with the 1998 Act, not GDPR, because of the date in which the alleged breach occurred. And I'll come back to talk a bit about misuse of private information and that sort of common source argument in a moment. So what does Section 13(1) say? Well, it says that an individual who suffers damage by reason of any contravention by a data controller of any of the requirements of this Act is entitled to compensation from the data controller for that damage. And what the claimant, Mr. Lloyd, argued, and he was supported by the Information Commissioner, is that in this context, damage includes loss of control over personal data, as Martin has said. And we know that damage for the purposes of section 13.1 includes things like non-material damage, so distress, and we get that from the Vidal Hall case, which Martin mentioned. But the argument here was really whether damage in the context of section 13 also meant loss of control. And why is that significant? Well, you'll have spotted from looking at the text of section 13.1 that it doesn't mention loss of control, nor is there loss of control mentioned elsewhere in the Data Protection Act. And the claimant's position in this case was accepted. Loss of control would essentially mean the right to obtain compensation for a contravention of the DPA without having to prove damage. So a breach would equal a right to compensation without having to prove anything else. So if we move on, we'll see what the court made of that. The court found that section 13.1 cannot be interpreted as giving an individual a right to compensation without proof of material damage or distress. And that was a significant answer because it means that there was no right of action in Mr. Lloyd's case, and that carries across to other prospective group actions involving loss of control in data protection claims. And as Martin says, there were a number of these sorts of claims in the background. So a really significant decision from the court. The court reached the view primarily because of the language of section 13 and that it does not support recovery for a mere contravention, and that's a matter of statutory interpretation. And if we move back again to look at section 13, what you see here is an individual who suffers damage by reason of any contravention. And what the court really said is that if you look at that language, there is a distinction between damage and contravention. And if those meant the same thing, then the Act would have said so. So if Mr. Lloyd was right, the Act, in simple terms, should have said something like, if there is a contravention, then a person is entitled to compensation. But it doesn't say that, and the court was very clear in its ruling. And I think the Supreme Court's reasoning here is actually deceptively simple as a matter of statutory interpretation. The Supreme Court looked elsewhere to see if there was any other guidance that could help their interpretation, and they noted that Article 23 of the directive, which implemented data protection in Europe and was the basis for the 1998 Act, they noticed that it was not in dissimilar terms to section 13, and it also had an equivalent distinction between damage and the contravention. They also looked at national laws prior to the directive coming into force, and those national laws didn't require compensation for all breaches of the DPA, so there was no evidence of any attempt when the directive came into force that it was trying to adopt a common approach to that issue across Europe. One of the arguments that was made is that under the Data Protection Act, it has a common source with claims for misuse of private information. And I'm going to turn to look at misuse of private information in a moment and what the court made of that common source argument. But the final point the court made clear is that it was not considering the position under GDPR or UK GDPR as we now have it, because GDPR is a later piece of legislation, it can't help you in a question of interpretation about what the Data Protection Act means. And if we think about whether GDPR would have helped Mr. Lloyd here, well, the relevant article for GDPR is Article 82.1, and it talks about a person who suffered a material or non-material damage as a result of an infringement. So that's helpful because we know from non-material damage that we're talking there about distress. But again, what's noticeable is there is no mention of loss of control in that provision either. There is obviously mention of loss of control elsewhere in UK GDPR in Article 85, but the provisions in Article 85 are about or not about compensation. Those are about notification requirements and the provisions that do deal with compensation in the recital of GDPR, again, make no reference to loss of control. So there's an open question really as to what would happen in a case where Mr. Lloyd made the same arguments but under GDPR, and whether Article 82 would provide a means of compensation. And there is an Austrian case called UI, which is due to consider the meaning of Article 82. But of course, in post-Brexit, the UK courts are not bound by any decision of the European Court of Justice. So even if the European Court says that there was a right to damages for loss of control under GDPR, then that may not need to be followed by the UK courts. So I'll move on to talk then about misuse of private information cases. So misuse of private information is a distinct type of privacy claim. It's typically a claim brought by media personalities or other high-profile figures. And the key decision is a case called Gulati, which is about phone hacking, and where the court said that damages in a misuse of private information case are an award to compensate for a loss of a right of control of formerly private information. And there's often overlap with other types of action, but it's different, for example, from defamation, because it can be about reputational harm from a matter of fact which is true, but those facts are protected by privacy. And of course, in defamation, something that is true cannot be defamatory. And just a couple of examples of how that's worked in practice. The Cliff Richards brought a misuse of private information claim and was awarded £2 million in damages after the BBC showed rolling footage of the police raiding his house. Katie Price talked about and shared footage of her ex-husband, Mr. Reid, dressed in women's clothing and engaging in sexual conduct, and he was awarded damages under a misuse of private information case. And perhaps most high profile is the case involving the Duchess of Sussex, where the Daily Mail published a letter that she'd sent to her father in private in August 2018. And again, she was awarded damages for misuse of private information. The key contrast here is that in these cases, damages can be awarded for loss of control without the need to prove material damage or distress. And the court explained how you work out compensation for interference with right of control. And the way you do that is by calculating damages based on what a reasonable person would have paid for the rights of the user. So you think here about a hypothetical negotiation between the parties and the value that would be placed on the information to give the wrongdoer access to use the data for their purposes. So here it was about how much would any individual have been entitled to charge Google for using their data and monetizing it. What's interesting is that until the Supreme Court decision in Lloyd, it had been questionable whether that approach to damages could be used in an information law case as opposed to a case about misuse of property. So that's what misuse of private information is and how it works in terms of calculating damages. What did the Supreme Court have to say about it in Lloyd? So if we move on, I mean, the crucial thing here is that Mr. Lloyd did not bring a claim for misuse of private information. Instead, what he sought to do was advance this common source argument, saying that because both data protection law and misuse of private information were about protecting privacy, you could effectively read across the principles of calculating damages in misuse of private information claims to claims under the Data Protection Act. So those principles I've just talked about a moment ago. Well, the court's response to that was to say, well, they may have a common source in the European Convention on Human Rights, but so what? They're doing different things for different purposes, and there's nothing in the right to privacy under the European Convention on Human Rights or in the EU Charter that required the award of damages for a mere convention or I'm sorry, a mere contravention of a breach of a data protection right. So I suppose the question might be asked is, well, why did Mr. Lloyd not bring a misuse of private information claim then, if it's, it would have been easier to potentially calculate damage and establish them? Well, the Supreme Court explains this in a decision, and it notes that the view may have been taken that to establish a reasonable expectation of privacy, which is a prerequisite of an MPI claim, it would have been necessary to adduce evidence of facts particular to each individual claimant. And Martin mentioned the case of Vidal Hall. In that case, what the claimants did was they produced confidential schedules about their internet use. And they showed in that case that the information tracked and collected by Google was of an extremely private nature. So in Mr. Lloyd's case, he would have had to obtain an evidence in relation to each individual member of the represented class, and that would potentially be incompatible with bringing a representative claim for reasons Martin has discussed that, and Craig is going to talk about in a bit more detail. So I think that takes us neatly on to Craig and the procedural issues that the case raised.
Thanks very much, Neil. As Neil's indicated, I'm now going to talk about the procedural aspects of the Lloyd v Google case, and in particular the representative action utilised in Lloyd against Google. I'm going to contrast that with the collective proceedings which are on offer in Scotland, and consider how data protection breach data loss claims may be taken forward in Scotland. So, representative actions. Well, as set out by both Neil and Martin, the action was raised by Mr. Lloyd against Google as a representative action on behalf of an estimated 4 million users. So what is a representative action? Well, it's a vehicle for collective proceedings in England by a representative on behalf of a class of claimants. The main condition to be satisfied is that the representative has the same interest in the claim as the persons represented. Members of the represented class are not joined to the action, and any judgment or order given is binding on all members of the class, and accordingly the representative action procedure operates as an opt-out mechanism. So Mr. Lloyd, who was previously a director of Which magazine, decided to sue Google on behalf of a class of individuals in England and Wales who were allegedly affected by the Safari workaround. And the class was defined quite widely as anyone with an iPhone that was running Safari who had not changed the detailed user settings or the default user settings to allow third-party cookies. But as set out by the Supreme Court in its decision in Google, the representative procedure in England has existed for several hundred years. It has its origins in the Court of Chancery, dating back to the 16th century. There's a stock image of the Court of Chancery on the right hand of that slide, showing an impressive mace and a somewhat cavalier attitude to canines in court. Thereafter, the Supreme Court of Judicature Act of 1873 transferred all jurisdiction for representative actions from the Court of Chancery to the High Court of Justice, and the High Court rules provided that where there are numerous parties having the same interest in one action, one or more of such parties may sue or be sued, or may be authorised by the court to defend in such action on behalf or for the benefit of all parties so interested. Now, moving on from that, the rights or the provisions for representative actions are now set out in the CPR Rule 19.6, which is set out on that slide, which imposes no limit on the numbers of people who may be represented in the representative action. So as a brief canter through the background to the representative action as utilised, if we now move on to the next slide, we'll consider the group proceedings platform that's been introduced in Scotland. So for some years, there's been pressure for class actions or group proceedings procedure to be allowed across the UK, including Scotland. Now, collective redress in Scotland is a really new procedure in comparison, certainly with the history of the representative actions in England and Wales. So for the first time last year, groups of 2 or more people with the same, similar or related claims have a mechanism to raise proceedings together in a single action in the Court of Session. In Scotland, these class actions will be known as group proceedings. Now, in practice, the courts in Scotland have been operating a workaround to allow separate actions to run in tandem with the consent of the parties and the cooperation of the court. For example, personal injury claims such as the vaginal mesh cases, where parties chose test cases to run first and for all other actions to be put on hold meantime. But it's fair to say that there's been a demand for a proper system for managing groups of cases, and we now have that in Scotland. So the new court rules published on the 9th of July last year and came into force on the 31st of July last year, implemented Part 4 of the Civil Litigation Expenses and Group Proceedings Scotland Act 2018. Now, what does that provide for? Well, group proceedings will proceed on an opt-in basis. This means that potential class members must elect to join a class in order to participate. This is in contrast to the opt-out system used in the representative action used in Lloyd v Google. The opt-out proceeding basically has a definition where the represented individuals are automatically included unless they elect to opt out. Now, the group proceedings procedure in Scotland is currently opt-in, but the statutory instrument which provided for group proceedings also provides for the creation of opt-out procedure, but as yet no rules have been produced to allow opt-out procedure to proceed before the Scottish courts. We move on to the next slide. In Scotland, the principal requirement for group proceedings is that the group of claims must raise issues of fact or law, which are the same as, similar, or related to each other. Now, in the assumption that any future claim on a data breach or data loss type scenario would be in relation to factual circumstances as set out in Lloyd v Google, then that requirement would presumably be met. The court must also agree that there is a prima facie case, that proceeding as a group will be more efficient than as separate claims, and that there is a real prospect of success. Now, looking at data protection breaches and data loss incidents in Scotland in particular, as matters stand, were a group to consider raising proceedings in Scotland in relation to data protection breaches or data loss incidents, they would either require to progress them individually or by way of the group proceedings procedure. Now, proceeding by way of the opt-in group proceedings will require the group to advertise for others to join the group, and it will only be once a sufficient cohort has joined the group that will be worthwhile to consider group proceedings. Now, that's because litigation funders will be more inclined to back pursuers with lower value claims, such as that for data protection breach or data loss incidents. If the group is large in number, it's very much a numbers game for litigation funders. And the theory is that the funder will be better able to justify greater resource in pursuing the claims where the return is likely to be higher. Now, in Lloyd against Google, it was submitted that by the claimants that the representative action was only able to proceed by way of litigation funding if there was no need for compensation to be individually assessed. Now, the Supreme Court considered that a representative action for damages was only possible where the entitlement to damages can be calculated on a basis common to all members of the class. Further, it highlighted that the representative action could have proceeded by way of a bifurcated approach, dealing with liability firstly, and then leaving the individuals to proceed to recover damages as assessed individually or by way of a group litigation order if they were successful in establishing liability. Now, the bifurcated approach wasn't adopted by Mr. Lloyd. As I understand it, it was deemed uneconomic, as damages would only have been recovered in the second stage when individually assessed. And it would have been that point that the litigation funders would have been getting awards of expenses and such like, in line with the awards made in favour of each individual of the representative action. So since the aim of the new group proceedings rules in Scotland is to make it easier and more efficient for claims to be brought, it seems likely that we're going to see an increase in the number of low value cases proceeding in the Court of Session, grouped together. Why do I say that? Well, group proceedings should remove, or certainly lower, one of the barriers to pursuers bringing an action before the court, that is their exposure to expenses, either their own solicitor's expenses or awards made against them. So what's changed? Well, it's likely that there'll be an agreement between the members of the group and their solicitors taking on those cases, that the solicitors will accept whatever they're awarded if they're successful, or that they'll pick up the tab if they lose. So then turning on to consideration of whether or not this group proceeding structure will have the interest of litigation funders? Well, the group proceedings procedure is very much in its infancy in Scotland. There's only been one group proceedings application so far granted. That's in relation to the Volkswagen NOx emissions group of claims. I've sat in on some of the application hearings which have taken place virtually, and what struck me was that the court has shown itself open to considering all options as to how such group proceedings will be managed to conclusion. There was discussion as to whether or not a test case or cases or an issues-based approach would be most appropriate in taking the matter forward, or the group forward. It's possible that there might be an issues-based determination of the matter of liability and then test cases and quantum. Lord Ericht, who's the group proceedings judge, has indicated a willingness to consider options for the efficient disposal of group proceedings. But the approach to be used in the Volkswagen NOx emissions group will be determined at a case management conference, which I understand is due to proceed next month. So the initial impressions of the court's approach to group proceedings in Scotland is to point to its flexibility. And this flexibility may assist claimants who are seeking to progress Scottish data protection breach or data loss cases by way of group proceedings in Scotland. Group proceedings don't preclude claimants from joining together where they will each have claims for damages which will require to be individually assessed. And certainly the court might be persuaded to address liability issues before considering how best to address the individual damages. In the vaginal mesh cases, for example, which was case managed under a court of session direction, the pursuers each had claims for damages that required to be individually assessed. The court required them to lodge individual pursuers' packs with information and documentation sufficient to allow the assessment of their individual claims. And then test cases were selected to inform assessment of damages of a suite of individuals determined to cover a spectrum of the cases. So data protection, data loss claims could and arguably should proceed together if they're raised in Scotland. The Scottish courts would not be keen to see them proceed individually. You can say that. The procedure seems flexible enough to allow them to proceed to conclusion, including a way for providing individual assessment of damages. So this may well provide litigation funders with sufficient comfort to hold their interest in proceeding by way of group proceedings in Scotland. But I think that the main question is whether sufficient numbers of claimants can be persuaded to opt in to that group. The damages potentially recoverable in these cases are likely to be minimal. And it may be that not enough claimants will care enough about the breaches alleged to opt in for what might be fairly negligible damages. And if they don't, then the cohort won't be large enough to entice litigation funders to back them. But we'll have to wait and see. I'll pass back to Martin now, and we can pick up on any questions that have come in, which I haven't yet seen, but Martin can no doubt let us know.
Yeah, thanks, Craig. Thanks, Neil. So yeah, we've got a couple of questions, but please do use the Q&A function if there's anything else you'd like to ask. You've got a couple of minutes to go through any questions that you might have. Neil, I'll maybe start with you. I guess privacy claims in the Scottish courts have to date been a fairly limited number of things that we've seen coming through. What impact do you think Lloyd is going to have on claims in Scotland? And I suppose firstly, are the Scottish courts bound by the Supreme Court decision, bearing in mind that's come through the English litigation process, or could the Scottish courts reach a different conclusion on this?
So you're right to say that there hasn't been the same amount of privacy litigation in Scotland. I mentioned when I was talking about misuse of private information, this common source argument. So all privacy actions come from, firstly, the Article 8 of the European Convention on Human Rights, which establishes a right to privacy. But there are different approaches in the different jurisdictions. Privacy litigation, when we talk about a common law right to privacy or a misuse of private information claim, that's probably in its infancy in Scotland, but certainly developing in that way. And I think the Scottish courts would have regard to what the Supreme Court said about misuse of private information claims. There's a technical point about whether, in fact, that as lawyers would call it, what the Supreme Court said there was obiter, which means it's not, binding on anybody because it's not part of the court's decision. But I think we would certainly have regard to that, because there was a really quite thorough analysis of misuse of private information claims in the Supreme Court's decision. And as to the interpretation of the Data Protection Act, well, the Scottish courts would be bound by that, because that's obviously a provision that applies UK-wide, and I don't think the Scots courts could depart from what has been said in the interpretation point and what Section 13 means.
Okay. And Craig, the result in this case is clearly an obvious blow for claimants and litigation funders in terms of data breaches. One question that has come in is just whether the Supreme Court decision made any reference to the Scottish Group Action Procedure in its judgment, or whether it was looking solely at English claims. But I suppose if you could maybe answer that, then also I suppose thinking ahead on what you're talking about in terms of the Scottish procedure, do you think the Scottish courts would be sympathetic to trying to help claimants find a way of bringing these claims? Because it seems that the procedure and the cost of bringing claims for these is just disproportionate, and therefore, unless you can do it on some kind of group or class basis, it's just not going to be economic for anyone to actually bring a claim. So will the Scottish courts try and help people find a way to do this, or what do you think on that?
Yeah, we're dealing with the first part of that. Firstly, the Supreme Court wasn't really dealing with perhaps unsurprisingly, wasn't really dealing with the Scottish Group Proceedings procedure. Indeed, it was only dealing with one aspect of the collective procedure open to claimants in England and Wales. But we can take a lot from the decision as to how this would be treated were it to be raised as a group proceeding in Scotland. Dealing with the second part of the question, looking forward and how the courts would approach claims of this type being brought together in Scotland, I think I highlighted in my section, the courts will not want the court structure and court processes to be hit with all of these claims on an individual basis. Now, they've highlighted that there's 4 million potential claimants as part of the representative action. Quite how many would opt in, were that the requirement, is a different matter. But even if we were dealing with multiple hundreds of individual claims or thousands in Scotland, the court would certainly look to have them being dealt by way of a group proceeding, if that were possible. They would certainly not want the court structures to be crippled by a tsunami of these claims on an individual basis. And indeed, as you say, it wouldn't really be economic for each individual to raise these claims on an individual basis for the sums that we're talking about. So the court would certainly be open to them being dealt with by way of a group proceeding. There is still a number of hurdles that would have to be overcome to allow the court to be persuaded that the application for the group proceeding should be granted. But yes, there would certainly be an appetite on the part of the court to have them dealt with by way of a group rather than individually.
Okay, thanks. And another one, just I suppose thinking about the impact on organisations that are headquartered or based in Scotland. Obviously, there are many organisations in Scotland who will have customers, employees, individuals whom they hold data across the UK. And I know that claimants tend to raise actions in their local court. So an English data subject might raise an action under English procedure when the organisation, the controller, is in Scotland. But I guess they would have the option to also bring a claim in Scotland instead, based on where the controller is based. Do you think anything in this makes it more attractive to bring a claim in Scotland if you're in that group? Could we see people sort of forum shopping to a certain extent, or is there no real advantage or disadvantage between the two jurisdictions?
It's a good question. I think because the group proceedings procedure is in its infancy at the moment, anyone choosing to forum shop and raise group proceedings in Scotland is doing so by relatively leaping into the unknown. But that being said, the court has shown itself willing to be flexible. There's contrasts between the way that claims are brought in Scotland in general, between the way that they're brought in England. For example, it's my understanding that it's a good deal cheaper to raise claims in Scotland, so that might be an attraction. There's also not quite the same requirement for pre-action disclosure or pre-action correspondence, which might make it attractive to raise in Scotland as opposed to England. But these are fairly small matters. The real nub of this is, can a litigation funder get the sufficient numbers of claimants to raise in Scotland as opposed to raising in England and Wales? And it is very much a numbers game. So if there is sufficient numbers in Scotland, then you'll see claims being raised in Scotland by way of group proceedings. If not, then you won't.
Okay. I think we've got time just for a couple more questions. So another one, and I guess this is looking into the future, but someone asking about the approach taken in the US in terms of courts there, and they have been quite creative in terms of how they deal with class actions. Obviously, there's been a lot of headlines over the years around very high profile claims into the hundreds, if not billions, if not billions of pounds for various claims. And the question, I suppose, that's being asked is whether we think that there might be any change law in terms of statutory changes to allow individuals to bring these low value claims, or to simplify the process. And I appreciate that's maybe trying to second guess what the government may or may not do in response to this, but I don't know if either of you have a view or thoughts on that.
Yeah, I'm happy to start on that. I mean, Craig's obviously outlined the procedure. It's early days at the moment in Scotland. As Craig mentioned, the proceedings are opt-in. There was a provision and discussion about whether those proceedings should be opt-out, but the only type of opt-out class action we have, which would be more akin to the US style action, is in competition law, which was specifically set out in legislation and corresponding court rules. So I think you would need to see something in statute potentially, but judges can be creative, and what you saw in the Supreme Court was actually quite an inventive attempt by Mr. Lloyd to use the procedure, and the Supreme Court looking at that. But in its decision, they obviously did talk about, well, would it have been different if he brought a misuse of private information claim, or would it have been different if he'd used the bifurcated approach? So there is still scope to argue, I think, and ways in which you could maybe potentially bring in class actions with the existing framework in both Scotland and England. But I don't know if Craig's got anything else to add to that.
Yes, I think that rounds a bit covers it, Neil. But I think that there would require to be some significant opposal to the opt-out procedure. Yeah. And I think that if that is to go forward in Scotland, then it would require some significant discussion. I don't think I haven't seen terribly much appetite for that to come in. Certainly not whilst the opt-in procedure is still in its infancy. Yeah. And as to what any governments would do in terms of statutory framework to allow claims of the type sought to be put forward by Mr. Lloyd to go forward, I'm not sure there's significant appetite for that.
No, I agree with that.
And just one final question to finish up. I mean, this is looking, I guess a lot of us who are on today's call will have had these letters over the last couple of years, but we've had following minor data breaches, and I know that there's been, for example, individuals trying to seek damages for misuse of cookies on websites by not having proper notices and things like that. These proliferation of letters for £500 or £750 from individuals, and they have cited Vidal Hall, and then latterly Lloyd versus Google following the Court of Appeals decision for damages, and some of them have argued invasive loss of control. Do we think that's the end of the line for these sort of letters, or are we still going to see lots of small claims from individuals? I suppose moving away from the class action, but just individuals sticking these letters in after a one base might be a fairly minor breach.
Yeah. So, I mean, I think we are still going to see those letters, because if this decision has a chilling effect, it's going to take a bit of time for that to bed in. And of course, you can't stop people writing letters to say that they believe that they have a claim. Of course, a data controller's response to that is now being strengthened to say, well, it's no longer good enough just to point to loss of control, and what is the actual actionable damage here that you're seeking to recover. But notwithstanding that controllers might say that, you will still have a letter to respond to, and still have the risk, I think, of individual simple procedure in Scotland or small claims in England being brought.
And I guess there's a strategic point here that if you do suffer a cyber attack or a data breach, then you need to think carefully about how you approach this and how you respond, because paying out damages or making a compensation payment to one individual as a goodwill gesture may then open floodgates for others to stick in another letter. So I presume it does require you to take a step back and think, how strategically are we going to deal with this? How many letters are we going to get? Absolutely. Yeah. Okay. That, I think, is probably us up to time in terms of the number of questions we can cover. I hope you find today useful. Thank you for joining us. We will send out after the event a link to the recording of this webinar so that you can watch again if you wish, or share it with colleagues. Just a quick advert, we are back on, I seem to be doing a residency on the Brodies Zoom channel this week, so I'm chairing a session tomorrow with as part of our Cyber Bytes series, which is focusing on incident response. So we are going to be joined by Federico Charovsky and Mark Cunningham-Dickey from Quorum Cyber, who are going to be talking about incident response and the top 3 things to do and not to do if you suffer a cyber attack. So that should be a really interesting session. If you would like to join that, you can do so through the website. And also another reminder that we have our autumn data protection and GDPR update on the 9th of December, which will be me and Grant Campbell talking about the latest development in relation to all things data protection. A lot of discussion, I suspect, on international transfers, some of the new codes of practice from the ICO, and other matters. So again, if you want to sign up for that, you can do so through the website. And all that I think is left for me to do then is just to ask one favour. When you leave this webinar, you'll get a prompt to complete a short survey. We would really appreciate it if you could spend just a few moments doing that. We really value the feedback we get on the events that we run. It takes less than a minute, and I know this because when we do get the results, we actually see how long it takes people to fill in the answers. So it is 30 seconds tops just to run through it. If you could do that, we really would appreciate it. And we look forward to seeing you again on another webinar soon. Thank you.
Thank you.
Thanks very much.